Hey guys, today we are going to talk about the defense to negligence known as contributory negligence. Historically, contributory negligence was a complete defense. What this means is that if you sue somebody for negligence and you are partly to blame for his negligence, it operated as a complete defense. That means you will lose and you will not get any compensations because you were partly at fault. Because of the unfairness that may result from this complete defense, the Parliament enacted this legislation known as the Contributory Negligence and Personal Injuries Act, which provides that if a person suffers damage as a result of partly his own fault, his claim will not be defeated, that means will not be cancelled because of his own fault, but the amount of damages that he can recover from the negligent party will be reduced to such extent as the court thinks just and equitable, having regard, that means factoring, considering the claimant's share of the responsibility for the injuries caused to himself as a result of his own as a result of his contribution to the negligence. When assessing the contributory negligence of the plaintiff, the person suing, the standard of care that is used to judge him is an objective one. So a claimant will be contributory negligent if the court finds that he failed to take reasonable care of himself according to the standards of a reasonable person. That's why it's objective. It is judged as to what the standards of a reasonable person would take the steps. A plaintiff's own negligence will result in a reduction of damages only where it is causally relevant. That means it is relevant to the damage that he has sustained. So he sustained some damage, he partly contributed to the damage that he sustained. There has to be a causal relevance to the damage. The Singapore High Court in Ng Weng Cheong and So O Lu held that where the negligence contributes to the accident itself, the negligent behavior of the plaintiff contributes to the accident, such as where the plaintiff runs across the road without using the pedestrian crossing, or where the plaintiff runs across the road when there is a red light, the traffic light is red, his damages, the damages that he can claim from the defendant will be reduced substantially. There will be a greater reduction of his damages because he's at fault. He ran across the road when there's a red light. He ran across the road when he didn't use the pedestrian crossing. The English case of Froome and Butcher also held that where the claimant, the plaintiff's negligence contributes only to the extent of his damage, that means the amount of the damage that he suffered, then the reduction in damages is usually a small reduction. So for example, if the person sues someone for negligent driving, but he did not wear a seat belt, okay, and then he was involved in a crash, and then he got injured in the car crash. Or for example, in the case of a motorcycle, he sits on the motorcycle and did not wear a crash helmet. Then he hits his head and he gets injured. Under such circumstances, where his negligence in not wearing a safety belt or a crash helmet contributes to the extent of the damage, then the reduction in the damage is small. Why? Because the accident would already have occurred in any case, but his negligence contributed to the extent of the injuries, but not to the accident itself. In the Singapore case of the administrators of the estate of Tan Ah Hock, the Singapore court held that in situations where the claimant, the plaintiff, and the defendant are equally to blame, then the amount of damages awarded to the claimant will be reduced by half since they are equally to blame. So thanks for watching this video on contributory negligence.